For those of you guys who are maybe a little nosy, we found out from all this drama regarding the restitution and him not wanting to pay the additional. Well, we found out just how much money was being sent to Kohberger while he was incarcerated, roughly. Wow, my hair looks really dark. Judge Hippler has made his decision in the battle for restitution in Kohberger's case. We had a stream last week covering this, and honestly, I thought I mentioned this before, but I thought the stream was going to be kind of like, like I thought the hearing wasn't going to be too crazy, but it did end up into a sort of a battle between the defense and the judge. And it's a little bit yikes when the state kind of just sits there and just watches the ping pong back and forth between the defense team and Judge Hippler.
That is not my reading of the code.
Even allowing your reading of it,
All of the things that you just listed are pure speculation.
you took advantage of the plea agreement to get.
And that's why.
Are you in violation of the plea agreement by arguing that your client shouldn't have to pay those?
We are not in violation of the plea agreement.
What's the point of the plea agreement on restitution if the defense is able to argue against the rest?
Judge, again, in our pleading,
there was a motion on the docket, and it kind of confused me because it was a state's request for restitution. I did notice this where the state, they asked for restitution, and I was a little confused because I was like, wait, I thought restitution was already part of the plea deal. Why is the state asking for restitution? I thought that was already done deal with. So I saw this and I was like, oh, this is weird, but I don't know. What the hell do I know, right? So they asked for restitution against the defendant, Kohberger, and in favor of Steve and Chrissy Gonzalez in the amount of 20 grand, and in favor of Karen Laramie in the amount of 6,920. But part of the plea agreement, Kohberger was to not contest any of the restitution that the state would seek on behalf of the victims and the family members. And then we saw this, the defendant's objection to the state's request for additional restitution. So I saw this and I was just like, okay, well, I thought you already agreed to pay for restitution. So I'm a little confused what's happening here. The defense is going to have three objections. The first one is that, well, the state had 60 days to put together how much Brian's going to pay for restitution, how much the expenses are going to be for the funerals and stuff like that. And it seems like maybe the state went outside of the original 60 days. Secondly, well, it seems like the family members, they were able to raise money from third-party websites such as GoFundMe. So, it seems like they got the money. And then lastly, the third argument is that, well, Brian Kohberger is going to be spending the rest of his natural life being incarcerated, so he technically doesn't have the means to pay for the restitution anyways. The grounds for objection are that, one, the plea agreement specified funeral expenses and funds reimbursed through the Idaho Crimes Victim Compensation Fund in the amount to be determined within 60 days for July 23rd, 2025. Kohberger stipulated to those amounts, resulting in court orders in the amount of around 29 grand on August 29, 2025. The additional funds sought do not qualify as an economic loss because Steve and Chrissy Gonzalez and Karen Laramie received extensive funds through multiple GoFundMe campaigns that specifically asked for and covered the expenses sought. And number three, Kohberger has no ability now or in the future to pay for restitution because he is serving 4 consecutive life sentence plus 10 years. But even though you might not think he has the ability to pay, sometimes if you're in jail for the rest of your life, you end up picking maybe hobbies, right? And maybe you can make money off of that. Or sometimes there is prison work stuff that's being offered to you. And no, although you might not make a lot of money, maybe you make $3 a week or something like that, it's still some money, right? That you can basically pay towards the victims and their family members. And then we had a reply by the state. And this is where it was cleared up even more. The state essentially said that, oh, you know what? We kind of made a mistake. We told the family members that the crime victims compensation would reimburse them for expenses, incurred for traveling and lodging for any of the hearing. And it seems like we kind of messed up. So that's why we're asking for this additional money. So we're not only asking for what's outlined in the plea deal, we're also asking for money that's not covered in the crimes victims compensation. At the time of the plea agreement, and here's the big thing, the state was under the impression that certain expenses incurred by the victims' families would be covered by the crimes victims compensation. So that's what happened. That is why the state kind of fucked up. And I wonder maybe they just got bad information from someone that was working in their office. Maybe the Crimes Victims Compensation's office, maybe they were like, yeah, we'll cover it. And then they end up not covering it. Or maybe the state thought it was going to be covered, but they didn't double check with the Crimes Victims Compensation. Like, I don't know what happened, but it's a pretty huge fuck up, it seems. After the sentencing hearing, the state was informed that Crime Victims Compensation will not cover travel and lodging expenses for attendance of court proceedings. On behalf of the victims, the state submits the itemization of expenses that were incurred by the victims' families, including expenses not covered by Crimes Victims Compensation for the court's consideration. And remember, a lot of us did think that it seems like the plea deal happened pretty quickly. If I remember correctly, it was the defense that went to the state. And over the weekend was when they were talking about this plea deal. And I remember the family members were kind of like, whoa, like what's happening here? You know, and some of them were pissed. I wonder if things just moved really quickly to the point where maybe the state didn't really do a good job at double checking everything to make sure that, like, hey, you know, we're going to do this plea deal and let's make sure that, you know, all the expenses are going to actually be covered by Crimes Victims Compensation. And that way we don't have to include it in the restitution part. So I just wonder if it was like super rushed and this was just an overlook, but it seems like they fucked up. They told the family members that, you know, we're going to cover for your travel expenses and lodging. I'm assuming the family's members paid out of pocket or through the GoFundMe. And yeah, and then they're like, fuck, well, let's try to ask Kohberger for more money. And then now the defense is fighting it. So when they went and had a hearing, the hearing happened about 10 days ago. And I knew this was on the docket, but I didn't watch it right away because I was like, you know, like, I don't know. It might be like a boring hearing. Might not even be a big thing. Boy, was I wrong. The hearing was... The hearing was actually pretty spicy. Kohberger's not present for the hearing. The state is going to start off with addressing the fact that, yeah, we messed up and we thought that the victims and the family members were going to be compensated. And we gave them, boy, do we give them wrong information.
It is true that before trial, the families approached our office asking if there were any resources we were available to pay in advance for travel expenses or expenses related to them attending trial itself. And we looked into that, our staff looked into that, and advised them no. It was my understanding, and I'm mistaken. I realized I was mistaken at this point, but it was my understanding back in early July, late June, when we were talking about the plea agreement, that Crime Victims Compensation could be available to reimburse expenses like that.
Okay, so he's owning up to it. He said it was my mistake. He's not saying it's our mistake, you know, Ashley and my mistake, but it seems like he's the one who's owning up to the mistake of believing that these expenses will be reimbursed.
I now know that's not correct, and it was certainly my mistake. I will own it as far as our state of mind going into the plea agreement.
Yeah, but then like, can you imagine though if there was no GoFundMe? If there's no GoFundMe, and then let's say they spent, I don't know, 10 grand, 15 grand going from Moscow, or actually, you know what? Not even all the family members are in Moscow, actually, because it's a university.
It's pretty well settled that plea agreements are interpreted as contracts, which they are. I think it's pretty well settled contract law that a unilateral mistake does not relieve one of its contractual obligations and restrictions. So how can I order this restitution if the express terms of the plea agreement, though mistaken understanding by the state, don't allow such extra crime victims compensation fund reimbursement?
Yeah, because he's essentially saying that the contract has already been executed. It's a done deal. Yeah, there was a mistake made, but like, how can I go back and adjust a contract that was made between the two parties? Yeesh. After the judge mentioned that this is essentially a contract between the two parties and he can't just go back and just adjust it because, you know, someone made a mistake, the state was like, yeah, you know, we're going to go back and we're not going to ask for the additional restitution for the traveling expenses and the lodging because we understand that, you know, we can't really ask for that. So we're just going to go back to the original plea deal where it does cover funeral expenses, and we are going to be asking for additional restitutions to cover for the urns. And I think that totaled around like $3,700.
We are not affirmatively advocating for the travel expenses and lodging expenses of the family because we do not believe that we can legally advocate for those. So what the state is actually requesting today is just additional restitution for the funeral-related expenses, which are the urns for the families.
And then moving on to the next issue, addressing the defense's concern that, well, Brian Kohberger, he can't pay restitution anyways because he's going to be incarcerated. Now, the state is going to make an argument for that, and they do mention that, well, yeah, he's incarcerated, but You never know what kind of assets he might come into, or, he might have an opportunity to make money somehow, even though he's in prison. Yeah, maybe he decides to sell his story, sell his side of the story or something like that. Maybe he wants to write a book. Maybe he wants to sell t-shirts. Like, I don't know, man. Isn't Jody, wasn't Jody Arias trying to raise money too? I don't know if she ended up doing that, but you have a lot of time on your hands, and Brian Kohberger is only, mid-30s. So who knows what he's going to do in the future, right? Maybe he doesn't end up making any money, but you never know what's going to happen. It's a long life ahead of him. Kohberger would obviously inherit money someday, and then people who send money to him. Yeah, I mean, high-profile cases, I wouldn't be surprised if people are like, hey, I'll send you some money or something, or, if you want to talk to me, or if they just want to kind of pick his brain a little bit. Yeah, I wouldn't be surprised if money gets sent to him.
And that there is a possibility of future monies, whether by virtue of the statute with the treasurer impounding proceeds from a story related to this, or perhaps from an inheritance from his family or others. We can't see into the future. We don't have a perfect crystal ball. The state's position is having this additional restitution place, which is really fairly minimal, would be appropriate, and have them available that if the defendant comes into assets, that the families would be able to try to satisfy the restitution orders from them.
And that seems like a quite fair argument from the state that, well, just in case Kohberger gets any money in the future, at least there would be something set that money will then be transferred to the victims and the family members for restitution.
Given that the state has clarified its position that it's only seeking reimbursement for the earns, it's my understanding that that amount is $1,420 for one family, $1,587.79, and then another $167.79, which would be a total, I believe, if my math is right, of
Like $3,000.
$3,075.58.
Oh, I think I said $3,700 earlier. It's roughly around $3,000. Defense attorney Massath is going to argue that, well, based on the victim's compensation code, the court still has to assess on whether or not Brian Kohberger has the ability to pay for the restitution. And we're going to argue that no, he doesn't have the ability to pay, even though that before the plea deal, he was getting money coming in. Well, that money coming in was primarily from his family members. Now that he's pled guilty, well, maybe the situation has changed. And I think that alludes to, well, will the family members want to continue sending him money now that he's pled guilty? I think that's still a possibility. I think it's possible that, let's say they don't send him money because they're like, oh, well, I don't want to support my son who murdered 4 people. Maybe later down the road, maybe they'll change their mind. I mean, he is going to be there for the rest of his life.
There's no way that Mr. Kohberger is ever going to profit from any sort of movie or book, because Idaho Code 1953-01 specifically precludes that.
Well,
and
it allows that monies are swept from his account for those income to pay certain things. If there's no debt for those certain things, then does the money not go then to the defendant?
that is not my reading of the code. Perhaps I'm reading that statute more broadly.
I'm going to try to get through this part a little bit quickly so we can get to the judge's ruling. But what the defense counsel is essentially talking about, a law that originates from, I think, the Son of Sam law, where we actually talked about this, I think like a couple months or maybe like last year, where the Son of Sam law is not what I originally thought. So back in, I don't know, it was like the 70s or 80s, there was a serial killer that was incarcerated. And because his story was so notorious, they were afraid that the serial killer would sell his story and essentially get to profit off of it. So they implemented this law called Son of Sam law. However, years later, I think, the Supreme Court actually found it unconstitutional. They said that it violated the First Amendment. And so other states tried to implement Son of Sam law, or like different versions of it, where I think like the states are implementing it now. It's changed to the part where you can still sell your story, yes. However, if your account hits, I think, $10,000, then the alert will go out to the victims, the family members, and they will be able to sue you in civil court for whatever amount or for like restitution. And then additionally, I think they also increase the statute of limitations for when they can go after you for the money. So I think it's like 3 years that you have from the amount, 3 years from the time that you got money in your account or something like that. I don't remember. But yeah, it was pretty wild to me because that was something that I did not know. I just thought that like, oh, you committed the crime, you can't, make a movie, you can't have a book, you can't profit off of it. But it seems like it's not what we originally thought it was. Now, the judge just make this argument to the defense that, well, let's say we take your interpretation of, the Idaho code. Well, let's say that Brian Kohberger can profit off, books, movies, whatever. Well, what if the family members, what if they decide to sell the story and then they profit off of it? And then they give all the money, all the proceeds over to Brian Kohberger. Shouldn't we still have him required to pay restitution? Because if the family members circumvented that by making the money themselves and then sending it to him, well, let's at least have this restitution set. That way, any money that comes in, it's going to go out to the victims and the family members. I think it was a 28 grand that was already part of the plea deal. And then now it's going to be $3,000 for the earns.
And if the money's there, it's there. If it's not, it's not.
All of the things that you just listed are pure speculation.
There's a history in the 3 years he was incarcerated of him receiving 5 figures put on his books. Doesn't that give the court some history to suggest that such contributions from whatever source may continue into the future? I'm not aware of his family having disowned him at this point and not wanting any contact with him. And even if they are, that doesn't mean that won't change. And you call it speculation. It seems.
Well, Judge, there is a judgment against him in the amount of $28,000, and certainly 20% of every dollar that goes into his inmate account is going to go towards paying that $28,000. Another factor that the court actually can look at under 1953-04 subsection 7 is other factors, and those factors that other factors that the court deems appropriate, and that can be collateral resources that the families obtained over $200,000, which definitely reimburse the cost of the earns in terms of economic costs.
I also want to turn to the plea agreement, because isn't a reasonable interpretation of the plea agreement that the defendant will not contest the state's seeking of restitution that is outlined in the plea agreement? Otherwise, why would it need to be in the plea agreement? It seems to me it's the plea agreement. A reasonable interpretation is the defendant is agreeing to pay restitution for those items that are identified in the plea agreement, which includes victims' compensation, which includes in this case funeral expenses. So you took advantage of the plea agreement to get the benefit of the bargain regarding the state's dropping of the death penalty. Why should you not be held to the plea agreement to pay the victims the costs of interning their children?
Yikes.
Judge, I believe that our pleading was clear, that we understood that earns fell underneath funeral costs, but that once we have a hearing on this matter, that doesn't eliminate the court's duty under 1953-04 to do the ability to pay analysis. And that's why.
Are you in violation of the plea agreement by arguing that your client shouldn't have to pay those?
We are not in violation of the plea agreement. If there was any violation of the plea agreement that took place, it's the state seeking this when the other expenses, when it was clear under statute and under the Idaho Victims Compensation rules that those were not reimbursable expenses.
But they've effectively withdrawn those requests and are seeking what's outlined in the plea agreement. Mm-hmm. What's the point of the plea?
So we went from Kohberger possibly not being able to pay for the restitution to, well, Judge, you can look at the scenario that the victim's family members, they were able to get the third-party donations to cover the earns anyways. And it's not like they had any sort of economic loss because they raised over $200,000 to the judge saying that the earns are part of funeral expenses, which is part of the original plea deal. Why are you guys fighting to pay it?
The agreement on restitution, if the defense is able to argue against the restitution called for in the plea agreement itself.
Judge, again, in our pleading, we objected to what the state has withdrawn as of this moment.
So my understanding is that she is making the argument because the state made its motion for additional restitution. And now, even though they are withdrawing the additional restitution for traveling and lodges, they're still asking for $3,000 for the earns. Because of that, we can make an argument that Kohberger doesn't have the ability to pay for restitution. Therefore, Judge, based on whatever code she mentioned earlier, you have to make an assessment on whether or not Kohberger has the ability to pay. The judge is like, no, I don't have to do that because the earns, isn't that part of funeral expenses that's already been outlined in the original plea deal? why are you fighting this? Why aren't you agreeing to just pay this? And then we get some like butting heads and goes back and forth, and you guys just have to watch it for yourself.
But it also says the state may seek restitution regarding funeral expenses, and they're simply identifying additional funeral expenses.
I don't know what more you want me to say about the earns other than.
What's
they
the point
are-
of the plea agreement if you're not going to be bound by it?
I agreed that it was $3,075.58.
But you say you shouldn't have to pay it.
What I said was that the court needs to do the analysis under Idaho code about his ability to pay.
Why
It doesn't
hasn't the defendant waived his right to rely on that ability to pay by agreeing to those expenses as part of the plea agreement?
I don't know how the court can enter this order today without engaging in the analysis under Idaho code because it's required. That's the way I review the case law and the code, that once there's a hearing about restitution, then the court has to engage in the analysis on the ability to pay.
So the agreement to pay is illusory.
No, he agreed to $28,000. We've agreed that earns fall underneath.
Does he have the ability to pay that?
No, he does not have the ability.
So
to
why
pay
did
that.
you agree to it?
Because it was a specific, we were provided with those receipts within 60 days. We were not provided with a receipt for the earns within 60 days.
So is your
Yeah, I think the receipts for the earn came a little bit after 60 days.
objection then a timeliness objection?
We did raise a timeliness objection in our pleading. I have thought about that and whether or not I think that it is a really valid argument to say that that's completely jurisdictional. I didn't to mean that the court can't take this under the review at this point in time. I didn't read the judgment language in such a strict fashion that I felt like we could say 61 days means the court's not going to not going to consider it at all. So it is past your 60-day deadline, but I don't know that that is completely jurisdictional in the way that you drafted your judgment.
Judge is quiet.
Anything else?
No.
Thank you.
Mr. Thompson?
Mr. Thompson, any rebuttal?
No, Your Honor, thank you.
Mr. Thompson's like, Judge, I heard what you were saying. I don't need a rebuttal because you already got everything.
All right, thank you. I'll take the matter under advisement, issue an opinion in due course.
We're going to get to the judge's order now. And I want to remind you guys that typically I will have chapters down below for those of you guys who was already part of the stream and you didn't the recap and you just want to jump over to the judge's orders. I will always have these videos. There'll always be chapters in there so you guys can navigate to wherever you want. So but let me know if the summaries are helpful for you guys, or maybe you guys didn't watch the original stream because this is the first time that we are uploading a video about the restitution. The judge did make his ruling roughly about 2 weeks later. So the state is requesting about $1,420 in favor of Steve and Chrissy Gonzalez and $1,587.79 in favor of Karen Laramie for expenditures made for the earns. Plea agreements are contractual in nature and generally are examined by courts in accordance with contract law standards. A plea agreement is ambiguous if it is reasonably subject to conflicting interpretations. The determination that a plea agreement is ambiguous is a question of law. Interpretation of ambiguous term is a question of fact. The plea agreement at issue provides the state may seek restitution orders regarding funeral expenses and crimes victims' compensation reimbursement in an amount to be determined. There are no other provisions governing restitution. There is no dispute that the expenses incurred for the earns are funeral expenses as contemplated by the plea agreement. The dispute is whether defendant agreed to pay restitution for funeral expenses as requested by the state or only after the court considers the facts set forth in an Idaho code. Defendant argues it is the latter. The court finds the former to be the only reasonable interpretation of the law. Now, the defense, they argued the latter, saying that, well, the court should do a pay assessment and determine whether or not Kohberger has the ability to pay the restitution. The court says, no, I just have to figure out whether or not the defendant paid for the restitution for the funeral expenses as requested by the state. If the parties intended the restitution only be ordered in the amounts to be determined by the court under a specific Idaho code, there would be no reason to include the restitution provision in the plea agreement, given that the state, on behalf of the crime victims, is already permitted to seek restitution for economic losses. By specifically including the restitution provision in the plea agreement, it is clear the parties intended to bystep this step with regard to two specific categories of expenses: funeral expense and crimes victim compensation reimbursement. Thus, because the defendant agrees the expense incurred for the urns are funeral expenses, he may not object to the state's request for the restitution under the ambiguous term of the plea agreement. The judge is saying that because there is a restitution provision in the plea agreement, there is no need for him to do this pay assessment. And that because they're asking for funeral expenses, well, that's already part of the plea agreement. Brian Kohberger should have to pay it. Now, remember, the defense did make an argument that, well, Kohberger doesn't have the ability to pay. And then additionally, the family members were able to raise money through GoFundMe anyway, so they didn't really suffer any economic loss. In determining the amount of restitution to order, the court must consider the amount of economic loss sustained by the victim as a result of the offense, the financial resources, the needs and earning ability of the defendant, and such other factors as the court deems appropriate. The statute further provides that the immediate inability to pay restitution by the defendant shall not be in and of itself a reason to not pay restitution. Rather, a court may order restitution based on the foreseeability to repay the award. Indeed, if a defendant is unlikely to ever meet the full amount of restitution, an order of restitution may be upheld if it does not require installment payments or deadlines, but simply gives the victims the present ability to obtain a judgment. The defendant argues that restitution for funeral expenses should not be ordered given his other financial obligations associated with his case and his inability to earn money. He argues his consecutive life sentences preclude him from earning through employment, and that because of a specific Idaho code, it prevents him from profiting from the crime by way of book, movie, or entertainment. The state responds that although the defendant may not be able to earn money during his sentence, it is not basis to deny restitution, particularly here, where the defendant has received significant financial contributions while incarcerated. The state further argues that by operation of this specific Idaho code, any money that would otherwise be paid to the defendant for future media contracts can be collected by the state treasurer to be placed in an escrow account to pay restitution orders recovered as civil judgments. That's what I was talking earlier about the Son and Sam law and the modifications to it. The economic loss sought by Gonzalez and Miss Laramie for funeral expenses total $3,000, $3,779. This is in addition to the criminal fines and fees of $250,000, a civil judgment of $20,000 each for the family, and about $32,000 in restitution orders defendant stipulated to in favor of the crime's victim compensation and the families of Xana and Ethan Chapin. The amount at issue presents a minimal addition burden. So they're like, Kohberger already owes this much. I mean, adding on the $3,000 for the urns, it's like minimal considered, all these other obligations. Further, he has received nearly enough through donations to cover the amount of restitution already ordered. So it seems like the amount of restitution that's already ordered was around, $32,000. It was like $28,000, I think that was mentioned in the hearing. And then I think now it's like $31,000. It seems like the amount of money that he was getting before he was convicted, before he went through the plea deal, it seems like it have already covered this amount of restitution. That's how I'm reading it. So it seems like he had already gotten about 20 to 30 grand. And of course, maybe that money's already been spent on, I don't know, phone calls, commissary stuff. Who knows? I don't fucking know. While these funds may no longer, be available to the defendant, it is foreseeable that he will continue to receive donations in the future, particularly given that much of the donated amounts came from his family. In addition, there's no reason the defendant cannot secure prison employment for remuneration. Given his limited needs in prison and his youth, it is foreseeable that through employment and donations, defendant may receive sufficient amounts over his life to at least come close to meeting his financial restitution obligations. In sum, although the court finds the language of the plea agreement obligates the defendant to the restitution in the amount requested by the state for funeral expenses, even if it did not, the court finds the requested amount is warranted under this specific Idaho code. Separate orders awarding $1,420 to the Gonzalez family and $1,600 to Miss Laramie for funeral expenses will be issued. These are the orders here. So $1,587.79 for Karen Laramie for the urns. This is interesting. With interest thereon at the judgment rate of 9.125% per annum from the date hereof until the paid in full. Wow, that's a high interest rate. And then for Steve and Christy Gonzalez, an amount of $1,420. Again, same interest rate, 9.125% per annum. So there's that. The defense lost their argument. The judge has made his ruling, and Kohberger will be ordered to pay for the $3,000 of additional restitution to cover for the errands for the Laramie family and the Gonzalez family. All right, guys. Well, that's it for today. Thank you so much for watching. I hope you guys have a good one, and I will hopefully see you guys maybe in the future in the live streams. Feel free to stop by, say hello. If you guys are new here, don't forget to subscribe. We would love to have you guys come back again, say hello. And other than that, guys, enjoy the rest of your week. I'll see you guys later. Bye. Oh, we're going to do some, we got to catch up with the Blake Lively and the Baldoni lawsuit. So I will be catching up on that. Fun.